judges of the United States Court of Appeals for the Fourth Circuit. Oyez, oyez, oyez. All persons having any manner or form of business before the Honorable United States Court of Appeals for the Fourth Circuit are admonished to draw nigh and give their attention, for the court is now sitting. God save the United States and this honorable court.
All right, be seated, please. Excuse me, Judge. Know that Judge Wilson is presiding. He's the chief of this panel. We're here at his sufferance. He's there on the televisions.
All right, please be seated. All right, we'll begin with our first case, United States versus Alicia. And Ms. Washer, when you're ready, be pleased to hear from you.
Good morning, Honors. Pooja Boyster on behalf of the United States. Taxes that seek to influence conduct are nothing new. That is what the Supreme Court said in NFIB when it upheld the shared responsibility payment as a tax. It got there by applying a functional test, one that looks beyond the statute's label and one that it had borrowed from its bankruptcy priority context precedent. This court also applies a functional examination. It did so in New Neighborhoods, in Williams, and again in Ray CT.
Let me just ask you a preliminary question, counsel. Assuming we are just purely arguendo, that we agreed with you that this was a tax, okay, just arguendo. Do we then need to get into the question of whether it's a tax measured by income or whether it's an excise tax based on a transaction? Do we have to resolve those questions if we arguendo to conclude that you were correct on the question of whether it should be called a tax?
Yes, Your Honor. This court would have to decide whether or not this is a tax measured by income under 507A8A. It's also a tax, an excise tax on a transaction under 507A8E, but it would not be given priority if it were not either of those. We think it's—
All right, but the point is—
Robinson's question was whether—
a second, let me just follow up on my question.
Yeah.
The point is, are you saying that finding it's a tax is necessary but not sufficient? That we've got to ask whether it's a tax measured by income or based on or an excise tax? That we've got to go into those questions?
If I understand Your Honor's question correctly, yes, the court needs to answer two things. It needs to answer first whether this is a tax, something that the district judge did not do directly because it got straight to its assumption that it was not an excise tax or a tax measured by income. Before it can get, this court can get to—
But just to make clear, I understand what you're saying, but why is it, if it's a tax, arguendo, why is it necessary to go into these other questions as to what kind of tax it is?
507A8 only grants priority to certain types of exactions, and it's those listed underneath 507A8.
Okay, and those are the two of the exceptions that grant priorities for the tax are the tax measured by income or an excise tax.
Yes, Your Honor.
Okay, so bankruptcy court just doesn't give priority to taxes across the board. There have to be certain specific taxes.
That's right, Your Honor. Although this court did say in New Neighborhoods that the category excise tax on a transaction was meant to encapsulate all other taxes that weren't otherwise covered by other sections of 507A8.
Mm-hmm. Okay, that's very helpful. Thank you.
Can I ask you something about the Supreme Court's case? I use the word Sebelius. All those letters, I have to memorize the letters and it's easier. It's Chief Justice Roberts' decision in Sebelius when he's speaking for the court. In part 2, he addressed the Anti-Injunction Act, and he made a couple of very interesting statements. There, he said the Affordable Care Act penalty was not a tax because Congress didn't label it as a tax. Congress had labeled a penalty when it wanted one and a tax when it wanted one within the same statute. And he said, Congress, however, chose to describe the shared responsibility payment imposed on those who forego health insurance, not as a tax, but as a penalty. And then he explained that Congress can do that, and it says, even if that label were inaccurate, basically suggesting that we're going to bypass the CF&I functional analysis, because if Congress chose to label it a tax, it was free to do so and have it treated as a tax. And then the whole analysis in that part 2 goes on to say, Congress cannot change the taxing power. Taxing power is for the court to decide, and it's a broader concept. And that's what they, of course, did for the constitutionality purposes, whether Congress would do it. But for purposes of looking at congressional statute versus a congressional statute, he said a tax is a tax is a tax, regardless whether it is a tax. Now, I know CF&I has this functional analysis, and if I had my druthers, that would probably be the much better jurisprudence, but this is a Supreme Court speaking more recently. And I personally see some tension between the CF&I case and the Sebelius case. But he says the Anti-Injunction Act, Affordable Care Act are creatures of Congress's own creation. How they relate to each other is up to Congress. And the best evidence of Congress's intent is the statutory text. And it said because the Anti-Injunction Act uses taxes and the Affordable Care Act uses taxes in some place and uses penalties, we're going to honor that. That's exactly what the court said. Then it came to analyze the taxing power conferred by the Constitution. And in that sense, it determined whether it could collect that penalty as a tax, and it said it could. But it always labeled that holding as for constitutional purposes. It says, it is true Congress cannot change whether the exaction is a tax or a penalty for constitutional purposes, and it underscored constitutional, simply by describing it as one or the other. But for statutory purposes, Congress has full control. And in this case, of course, they labeled it a penalty, and they labeled other portions of the Affordable Care Act as taxes. And in the bankruptcy code, they label it as a tax. And so you match them up under Sebelius. You don't do the functional analysis when Congress labeled it, even though it may have been wrong. That's what the court says. Now, you can persuade me the other way. That's my problem. And I'm just speaking for myself. But I must say, if we're going to read Sebelius as the last word from the Supreme Court on this subject, I have that difficulty. I don't quite know how to handle it.
Your Honor, two points in response. First, when the Supreme Court got to that functional analysis that it applied for the constitutionality of the shared responsibility payment, it took from its bankruptcy priority precedent, CF&I and Sotelo. So it knew it was applying a functional test that it traditionally applied to bankruptcy priority cases.
But it picked a functional test because the functional test looks behind the label, but it did it for constitutional purposes only. It didn't transform the bankruptcy statute because it just happens to be that's where, like CF&I did the analysis and said you look structurally. It seems to me the IRS has always taken the position that we look behind sham labels and look at function. My biggest problem is Sebelius itself. And the language they use is not a particular statute. If it's congressional creation and Congress labels it a penalty or labels it a tax, we follow that. That's exactly what Part 2 says. And that was part of the court opinion. Then they come for constitutional purposes going to the power of the mandate and the penalty. And they said that power was authorized under the functional analysis. And they drew back on how to apply a functional analysis, but it did it for constitutional purposes in this case. And in part 2, it seemed to say Congress can label it a tax, and it says even where that label was inaccurate. That's what the chief said. And are we supposed to ignore that?
No, Your Honor, you're not supposed to ignore that for the Anti-Injunction Act analysis.
They didn't say that. He said
It's a-
he made the distinction between acts of Congress and the Constitution. He laid out and he underscored constitutional. He said, it is true that constitutional cannot change whether taxation is a tax or penalty for constitutional purposes, because we're looking at the taxing power. But when we're looking at statutory enactments in which Congress has full control, we have to follow labels. That's basically what he said. I understand the tension. I understand your argument fully. And I must say, it's very persuasive, your argument is, but I don't know how to handle this stuff. I do. We're going to have to. That's our job. But I'm just telling you the problem I faced in preparing for this case.
When the dissent pushed the majority on its ruling as to the functional analysis and said, you cite Sotelo, that's a bankruptcy priority case. That has nothing to do with our constitutional analysis.
I understand, but see, all that does is give you the elements of a functional analysis. It doesn't tell when it can be used and when it can't be used. Back then, CFF&I says you do a functional analysis, but in Sebelius, they say you do the functional analysis for determining constitutional power, the taxing power. It said when it comes to statutory enactments, and they said these are creatures of Congress's own creation. How they relate to each other is up to Congress. The best way, evidence of Congress's intent is the statutory text. And if they label it a tax, the court said, regardless of whether it's a proper label, we use it, call it a tax. They label it as a penalty, we call it a penalty. And that language sort of says when we're looking at Congress's own enactments, applying one word to another statute, we follow. If Congress chooses to call it a tax, they can call it a tax. It'll call it a penalty. And it's a little bit more difficult in this case because within the Affordable Care Act, they did use the word tax and they did use the word penalty distinctly. And so if we're going to follow the labels, then in this case, a tax, the penalty is not a tax. Penalty is a penalty, which is treated differently. Anyway, that's I think roughly that's where the district court came out, wasn't it?
Counselor, I'm sorry, I don't mean to take up all your time, but I wanted to say that I thought your point was that when you did go into the functional analysis, it sort of walked like a tax and talk like a tax, and we're wedded to the functional analysis here. And you whether you pay the SRP, you decide it right at the time that you file your tax return. You include it with your tax return. It's tied to household income. In other words, it walks like a tax and talks like a tax. And that's the functional analysis. And then the other point I thought you were trying to make is that the label of, or the Supreme Court's view that this was a tax was made in conjunction with the very point that we are concerned with here. And that is, what is the SRP? It's not a general matter. It is what was the SRP? And you're saying, as I understand your brief, that when they address the question of what is the SRP, they said it's a tax. And my concern is that if we try to go off in the opposite direction, it's going to look to the Supreme Court as if we are essentially mounting a backdoor attack on the Sebelius case which I had my reservations about, but once the Supreme Court has spoken, I feel more comfortable following the Supreme Court decidedly, rather than giving the appearance that I'm mounting a backdoor attack of some sort on the ACA. That's what I thought you were saying. Am I correct?
Yes, Your Honor. It walks like a tax. It talks like a tax. It is a tax under the functional test. And just quickly to respond to Judge Niemeyer's concern, if the Supreme Court wanted to overrule its bankruptcy priority precedent, it would have done so explicitly. It was confronted explicitly with its CFNI holding and its Sotelo holding. And instead of distinguishing it in footnote 7, it says, just because this is a bankruptcy priority case does not mean we do not have to follow it. I think that is what lets us to conclude this is a functional test that applies in both, which is why we think that NFIB or Sebelius is controlling here. I see I'm dipping past my time, but if you're
No.
Let me ask, I understand that. And my point is, the court did apply a functional test, but the court applied a functional test and it said it explicitly 2 or 3 times also in the part that addressed it for constitutional purposes. It says we do this for constitutional purposes. It did that deliberately. We're applying a functional test. We're determining whether Congress had the power to tax or to impose the penalty, and they call it a tax under the taxing power. But it clearly made a distinction and went out of its way to make the distinction, even emphasizing words that we treat the taxing power interpretation under the Constitution functionally, whereas we're going to treat Congress's own enactments giving effort to its labels. And you say they overruled. I don't know if they overruled, but I do know Sebelius did not apply the functional test to congressional enactments, but did to the constitutional power. And that to me is something that that hurdle we have to overcome. So if we're going to be faithful to Sebelius, it seems to me we have to decide whether this is a constitutional question or a congressional enactment. And that's the distinction. It's the functional test. I understand that test, and that was borrowed from earlier cases. And the truth be, if we're going to follow it, that's what I think we have to follow. Now, CFNI sits there as a well-reasoned opinion that comes before, but I don't see how that's consistent with saying we're going to abide by Congress's labels, regardless of whether the label is correct.
If the Supreme Court hadn't recognized the traditional context in which it applied a functional analysis, I would agree with you, Your Honor. But it recognized that traditionally there are certain contexts, constitutional one, the bankruptcy priority one, where it does look behind the label. And this court, as Your Honor just said, has also applied a functional test in New Neighborhoods, CT, Williams. This is a functional test that applies. We argue that this is an income tax, a tax measured by income. The Third Circuit recently dealt with this very issue in Sizaporsky, and it said you cannot get to the shared responsibility payment amount without knowing a taxpayer's income. For that reason alone, this court can reverse the district court because this is a tax measured by income for 507A8A purposes, and it should be given priority. If the court wants to end there, it can. We think it could also reach the issue of whether or not this is an excise tax on a transaction. It does not have to. If it does, we think it should so conclude.
Well, if we found it was a tax, then we'd have to decide whether it's a tax as described in the bankruptcy code, wouldn't we?
Yes, Your Honor.
And if we defined it's not a tax, we'd not have to reach that.
That's right, Your Honor. Yes. This is also an excise tax on a transaction under 507A8E under this court's precedent in Williams. Just like the uninsured motor vehicle exaction in that case, the shared responsibility payment applies to individuals who are uninsured, even though the opponent would like to say that this is an inaction, so it therefore can't be a transaction. This is very similar to the exaction at issue in Williams. If the court reaches the issue, we do not think that there's any meaningful distinction between this case and the Williams case. I'll reserve the rest of my time for rebuttal.
We thank you very much. Let me ask Judge Traxler, do you have any questions you wish to ask of her?
No, thank you, Judge Wilkie.
Mr. Brewer?
Good morning, Your Honors. William Brewer here representing the appellee. I'm going to jump right into the discussion Judge Niemeyer was having. It does appear to me, before I get to functional analysis and all of that, which I intend to cover time allowing, that the Supreme Court did stray in Sebelius from the principle that the terminology employed by Congress in describing an exaction is not determinant of its application in a statutory sense. I would point to this court's decision in the Liberty University case, in which this court held contrary to Supreme Court that the Anti-Injunction Act did prevent the challenge to the ACA. That analysis by Judge Motz really kind of goes through the kind of functional analysis, whether it's a tax or a penalty, and found that it was in fact a penalty, was in fact a tax, and therefore was covered by the Anti-Injunction Act. And as Judge Niemeyer pointed out, the Supreme Court said, no, 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 no. For purpose of Congress passes a statute, says it's a penalty. There's an Anti-Injunction Act that says that that you can't enjoin taxes. They use the word penalty. The Anti-Injunction Act doesn't apply to penalty. That's what Congress has done. I would submit.
But how do you, counsel, how do you deal with the fact that when the Supreme Court was addressing this precise question, and that is, what is the SRP? They came to the conclusion that it was a tax, and it was a decision that was explained at great length. They went into a whole lot of different reasons why it's a tax. Those same reasons are present here. Just because the context is one of bankruptcy, it doesn't change the fact that when the Supreme Court addressed what the SRP was, it says it looks like a tax, and then it goes into the fact it's paid into the Treasury at the time that people file their tax returns. It raises revenue for the government. It doesn't even apply to people who don't have to file federal income taxes. It's just determined by questions such as taxable incomes, number of dependents, joint filing status, which is what a tax depends on. And it just seems to me that you are asking us to get on some thin ice and to come perilously close to simply rejecting what the Supreme Court said in the ACA, in the Sebelius case. I understand that's a controversial decision. I didn't particularly like aspects of it, okay? But for the system to work, we can't be nudging ourselves in a position of non-acquiescence or semi-defiance or whatever. It just, it puts me in a place where I'm not comfortable being.
Your Honor, whether one, I agree with you, whether one likes Sebelius or doesn't, it's a pronouncement by the United States Supreme Court to help you deal with your dilemma. How do I rule on favor of the appellee in this case without getting in the face of the United States Supreme Court? I submit to you, it's because the issue here is different than the one for the Supreme Court. The issue for the Supreme Court is, what is the constitutional power of Congress? And the law is that Congress construes statutes to to uphold their constitutionality where possible. So there is the presumption there to lean toward finding a construction of a law that upholds its constitutionality. There's in determining whether the SRP is a tax for purposes of the bankruptcy code has a totally different presumption. Priority statutes are tightly construed so as not to give priority from one creditor over another. That's the Supreme Court Howard delivery case. And therefore, it is a total different approach. And again, going back to our previous discussion, the Supreme Court says it can be a tax for constitutional purposes, but a penalty is what Congress called it, and that's what it is for statutory purposes. And I submit to you, therefore, to say that we can find it to be not a tax for purpose of the bankruptcy code in no way indicates that the Supreme Court was wrong in determining that it was in fact a tax for constitutional purposes. I think you simply do that. But
the Supreme Court adopted a functional analysis. We as well have adopted a functional analysis in our own opinions, and I don't understand why the same functional analysis would not carry throughout. That we are supposed to look at the functional analysis rather than labels to determine what this is. And it just seems to me, we use a functional analysis in this context to jump to this conclusion. We use a functional analysis in this context to jump to the other conclusion. It does seem to me that if you use a functional analysis, which our precedents do, that you want to follow through and be consistent with that. And the functional analysis leads in only direction, and nobody is really contending otherwise.
Your Honor, let me run through that functional analysis as this court laid it out in both Williams versus Motley and New Neighborhoods. And let me try to persuade you that functional analysis as supported by this court does not result in finding this to be a tax. Those criteria are an involuntary pecuniary burden laid upon individuals or property imposed by the authority of the legislature for public purposes, including the purpose of defraying expenses of government undertakings authorized by it under the police power or the taxing power of the state. I submit to you of those four criteria, 3 of the 4 really do very little to distinguish a tax from a penalty.
You know, I think that argument is probably going to lead you down a rabbit hole. It seems to me, while we can argue about what the functional analysis is, the Supreme Court did apply the functional analysis for constitutional purposes of this very payment. And it concluded, based on numerous reasons, that it explained that it was within the taxing power. So I'm not sure we can overrule. If you get to the point where you're arguing the functional analysis here should be different from what's in Sebelius, I think you're asking us to really play with the Supreme Court's holding. The Supreme Court held explicitly that for purposes of the constitutional taxing power, this was a tax under the functional analysis. My questions were not focused on whether the functional analysis of our Motley or any other opinion is the correct version of it. My point was the court made clear it was addressing the scope of the constitutional power, and the constitutional power could not be limited to how Congress labels it. That's what the court explained, and they even concluded the taxing power, that this was authorized under the taxing power. But then it made pretty clear that if this is a question of congressional enactments, two congressional enactments, then we have to abide by what the Congress said. But I don't think we get anywhere by having a debate or an argument about the functional analysis of this particular payment. The Supreme Court conducted the functional analysis.
They did the functional analysis determining the constitutionality.
I understand, but that doesn't change the term. A functional analysis is a type of analysis. In the functional analysis, you look over substance over form, substance over label. And so the Supreme Court said, looking over substance, it's a tax because, and then they explained why.
And I submit to you, Your Honor, that in fact, based on presumptions, you have cases that are very close. And a close case, is it a tax? Is it not a tax? For purpose of constitutional power, we're going to lean toward calling it a tax. But in the
the functional analysis is not some kind of chameleon that just shifts its colors from here to there. We are dealing with the same payment, a shared responsibility payment that the Supreme Court said was a tax. And we can't just wish away the Supreme Court's holding and say, well, they were doing that for constitutional purposes. Because I don't think if you adopt a functional analysis, I can't see it shifting around when we're dealing with the same payment. You know, I don't like this particular analysis, but it's not a chameleon. It doesn't, when you're dealing with the very issue that we're talking about here.
Your Honor, I submit is not the very issue. Congress's taxing power, there are within the Internal Revenue Code a number of penalties for late filing of tax returns and that kind of thing. That's clearly within Congress's authority under under its taxing authority to levy against people. However, those are clearly not taxes for purposes of the United States Bankruptcy Code. In this very case, the IRS proof of claim includes penalties that meet all those functional analysis. They are levied by the IRS. They show up on tax returns. They're collected by the IRS like taxes, but they are penalties. So there's the issue of what is within the taxing authority and what is a tax for purposes of Section 507A8 are in fact different, as the Zaporsky case held that. Now they ruled in favor of the IRS.
That's an interesting argument. Well, let me ask you this. If the IRS makes a claim for past due taxes in a bankruptcy case and includes in that claim penalties it has imposed, your argument is the taxes get priority, but the penalties don't.
Exactly, and
is that in practice? In other words, if they come in and a taxpayer doesn't pay a tax bill and has $100 in taxes due and $50 in penalties, and so the IRS comes in and claims $150, doesn't that whole bill get
priority? No, Your Honor, only the $100. The $50 penalty, as you described it, is a general unsecured non-priority claim, and that's. You look at the proof of claim, I think it's on page 1.
Well, then your argument is, I gather, has some support, because while the penalty is authorized to be imposed by the IRS under the taxing power under the Constitution, it is still a penalty for purposes of statutes if the Congress makes a distinction between penalties and taxes.
Exactly, Your Honor.
I understand.
Okay.
But this has none of the characteristics of a penalty. It doesn't even require kind of a finding of scienter. And normally when we have penalties, they have some sort of scienter. But that's done here. And this is not to penalize anything. It's not a punitive measure. It's not a fine or imprisonment or whatever, anything, any more than not paying my normal taxes is a fine or imprisonment. I would like to, I would like to think that when I file my tax returns, in the SRP, that I was paying a tax along with the other taxes I'm paying. But this doesn't even have the characteristics of a penalty.
Your Honor, again, getting back to my previous argument about late filing of a tax return, that's not unlawful. You pay extra money to the government for having done so. The government wants to deter one from not filing tax returns untimely, or from filing untimely, excuse me. Therefore, there's a penalty for that. And it's recognize everyone that's a penalty.
But this is not an untimely tax return. This is something that's, along with 20 other things, is part of the tax return. It's a lawful part of the tax return.
But what I'm saying, you're conflating the issue of how this act by Congress to deter certain action, failure to get insurance, how it's collected from what it in fact is. I will submit to you that the appellant's duty is to prove to this court it has the burden that this is a tax. You can say then it's not a penalty, but I don't have to prove it's a penalty. I have to prove it's not a tax. And I will submit to you that if you were to find this as a pecuniary burden placed upon individuals by Congress for its individuals' failure to get insurance as required by the individual mandate and the Affordable Care Act, then you can call it that. You can just call it a deterrent, whatever, but it's not a tax. And if it's not a tax, appellee prevails in this case. You can say, well, I don't want to call it a penalty because it is in fact, even though Congress called it a penalty, because they don't throw people in jail for it or do bad things to them for it. They just make them pay this money on their tax return. But I submit to you, it is still for the purpose of deterrence. When I get to that functional analysis, I will submit to you, it's the third one that is the most important. The first one says that it's an involuntary pecuniary burden. Well, that's a penalty. I mean, that didn't distinguish a tax from a penalty imposed by the legislature. That's the second. Well, that's, penalties are imposed by the legislature under the tax.
But there's just an element of incredulity here. When you get something that walks and talks and quacks like a duck and the rest, and then you sit here and you tell me it's not really a duck, and you tell me that it's something the Supreme Court has said is a tax, and it sure looks like a tax to me, and then I'm being told, oh, it's not at all what it seems to be. I mean, I'm just incredulous that somebody would sit and tell me that what's transparently a tax is not really a tax. It's like blue is not blue and red is not red and the rest. And I'm asked to stare reality in the face and to walk away from it.
I have temerity to say that it does not walk and talk like a tax. Tax, the main purpose of a tax is the third factor in the functional analysis, and that is the pecuniary burden placed upon individuals to defray the expenses of government. There is nothing in the Affordable Care Act, and if you read it totally and its purpose, that
it raises revenue is what, raises revenue, which is what a tax does. And the Supreme Court, Chief Justice Roberts summarized it by saying Congress didn't mean to create 4 million outlaws or whatever it would be. And if it was a tax, you don't create 4 million outlaws, whereas it's a penalty of some kind, you do. It's the difference between what is stigmatic and what is not. And as I say, I thought the Chief Justice summarized the point very, very well.
My time is up. May I respond?
You can make a concluding statement. I'm happy to hear you.
The fact that it comes down to the issue of whether penalty has to be an unlawful act. And I submit to you, it does not. It can be something that the Congress wants to discourage.
Well, why isn't, if it's a mandate and you have to buy insurance, shall buy insurance, why isn't it unlawful if you fail to comply with that?
Well, I guess it depends on how you, maybe it is unlawful, it's just not illegal, I guess. There's no criminal prosecution, you know.
No, there's a penalty.
It is in violation of what Congress has said to do. I agree with that. I mean, as this court knows, the enactment of this law has been controversial from when it was first proposed through even today. And so it appeared to me Congress was attempting to soften the blow by the way it described it, but it says, we want people to get insurance, you're required to get insurance, we want to increase the insured pool.
Thank you, counsel. Thank you very much. We've given you some extra time, and if either of my colleagues has any further question of you, I'm happy to defer.
Thank you, Your Honor.
Good. Judge Niemeyer, Judge Traxler, do you all have anything further to? Okay. All right, you're welcome to your rebuttal.
In Sotelo, the Supreme Court was asked to decide whether something that was called a penalty, like the shared responsibility payment here, was a tax entitled to priority. The Supreme Court held it was. It did so by applying a functional test. The Supreme Court in NFIB cited Sotelo and used that test to come to its same conclusion that the shared responsibility payment, while labeled a penalty, was a tax. That is the very issue before this court. Is what is otherwise called a penalty a tax because it is a functional examination?
How do you explain my biggest difficulty? I think, I understand that and I follow that clearly. It's the functional analysis seems to be logical, but it seems to me there is a tension in the conclusion that determine the scope of the taxing power, and the court clearly was addressing the taxing power under the Constitution. It applied a functional analysis to determine whether Congress could do it or not, even if they called it a penalty, if it looked like a tax or fell within the taxing power. But then the court says, when we're looking at enactments of Congress and they make a distinction between a tax and a penalty, we go along with their distinction. And that's in part 2. And they said, regardless of whether it's properly labeled, it could not have said that under the Affordable Care Act because they were improperly labeled. But they said, for purposes of congressional statutes, when one statute versus another, Congress can define it however it wishes. And if it calls it a tax, it's only a tax, if it's a penalty, it's a penalty. And I don't understand. I find a tension in that type of an approach because I understand the taxing power is a different source. That's a congressional source. And you may want to go more broadly to authorize the government to raise monies and enforce penalties and that type of thing. But when it comes to congressional enactments and they label something a tax, whether it's a tax or not, it seems to me that they sort of suggested by implication that we don't go with a functional analysis, we go by the label. How do we square that?
Every case that has come after NFIB v. Sebelius on this issue before this court, whether or not the shared responsibility payment is entitled to priority, has applied the functional test. No other court has had that concern. In fact, when the Third Circuit recently decided this exact issue, while it held that Sebelius was not controlling,
Did they look at part 2 and analyze part 2 of Sebelius?
they did, Your Honor, because they said it was persuasive to its own analysis. And in fact, when it answered every aspect of its functional examination in the Third Circuit, which in fact is asked more questions than this court typically does for bankruptcy priority, it answered each of those factors by turning to Sebelius. This court,
Would we be creating a square conflict with the Third Circuit here?
you would, Your Honor, and you'd be creating conflict with every other circuit that has had a district court or bankruptcy court that has applied a functional test.
All right, so in other words, we're going to be asked to be an outlier. Not only are we going to be asked to fly in the face of the Supreme Court's analysis, but we're going to be asked to create a conflict. We're going to be asked to be all out there by ourselves, way out on a limb, both defying the Supreme Court and creating circuit conflicts and conflicts with every other court to decide the question. That is what we are being asked to do.
That's right, Your Honor. And this court should not take the bait. This court should hold, because of Sebelius, and even if Sebelius didn't control here, the functional test requires this court to reverse the district court. This is a tax. It is a tax measured by income. And if this court also wants to reach the excise tax issue, it is also an excise tax on a transaction. The district court got it wrong on all three fronts. Not only did it fail to apply the functional test that the Supreme Court required of it and this court required of it, it failed to recognize that this is measured by income, even though it may not be measured by income alone. That's not the standard. 507A8A says measured by income. This is very clearly a tax measured by income, similar to what the Third Circuit recently held in Sizaporski.
Is there another court of appeals that has paralleled the Third Circuit?
The only other court of appeals to address the issue was the Fifth Circuit, and the income tax was the measured by income argument was not before it. So it held that issue had been waived. So it had not addressed it. The only other
So it's only one circuit, Third Circuit.
so far, Your Honor, yes.
Okay.
For the reasons I've discussed, I would like this court to consider the burdens that it is required to follow, not just its own precedent, but the Supreme Court's precedent. And we ask that it reverse. Thank you.
All right. We thank you both for your presentations, and we will proceed to go directly into our next case.
We, as you know, we would normally, Judge Wilkinson's remote, but we would normally come down and shake your hands. That's a tradition we have not given.
Mr. Hammond, whenever you're ready.
Thank you, Your Honor, and may it please the court. The decision below should be reversed because there are plausible allegations of deliberate indifference. There was a substantial likelihood that Neil Basta's right to effective communication was being violated. Novant knew of the substantial likelihood, and Novant failed to adequately respond. To set the stage further, Novant also knew that Mr. Basta was deaf and knew that his preferred and most effective form of communication.
Do you allege, or does the record, do you claim in the complaint that the hospital knew that their machines would likely fail?
Judge
And
Niemeyer,
what-
there's no allegation.
and then, of course, the second prong of the deliberate indifference test, if we were to apply it, would be that they failed to act despite that knowledge. In other words, I thought they assumed they were going to comply. They assured your client that they were going to comply, we'd take care of it. And when he got there, they gave him a machine, which would have complied, but the machine didn't work, apparently, it malfunctioned. I think that's what you allege. So they removed the machine and put in another one. Apparently it malfunctioned too. And so the question is that conduct deliberate indifference, or is that just negligence, or maybe not even negligence? I thought they assumed they had a responsibility. They thought they could discharge it, and they were unable to do so because of malfunctions. And we have to address whether that's intentional discrimination. That's the standard.
Yes, Judge Niemeyer, that is deliberate indifference. So they provided the first device that malfunctioned, as you said, then the second device. But after that device malfunctioned, nothing more was provided. Nothing more on the first day of the admission, and nothing on the second and third days of the hospital admission.
But they didn't know they were going to have misfunctions, and they didn't deliberately ignore it. Apparently, they didn't have any more machines. But the fact that two machines, they tried to comply, two machines failed, and they didn't know that in advance. If they knew it in advance and didn't do anything about it, or if they had experienced the prior week where they had failed two machines again, and they didn't do anything about it, that's indifference. But if they tried, maybe they were negligent, but we're talking about intentional discrimination. And I don't quite see why the hospital, they thought they were able to comply, and they tried to comply. And actually the machines, it was fuzzy and choppy, it was blurry and choppy, the machines were.
That's right.
Yeah.
Judge Niemeyer, the problem though is that there's no requirement of the advanced knowledge. Once they have knowledge that the device is malfunctioning.
Tell me what the standard, give me the standard that we had in Kuhn for deliberate indifference.
In Kuhn, the standard is three-part. First, substantial likelihood of harm to a federally protected right. Second, the defendant entity's knowledge of that substantial likelihood. And third, their failure to adequately respond.
Okay, so I'm addressing the knowledge of the likelihood failure of the machines. And the question is that pleaded? Is that shown? And I didn't see it. Now you can point to that if you wish. The second is that after having that knowledge, they ignored it or failed to act despite that knowledge. I think that's what Kuhn requires.
Yes, so starting with that second factor, in paragraphs 20 and 21, we discussed the malfunctioning VRI, where staff are present. In fact, the policy, which is paragraph 10, empowers the staff to provide devices. In fact, they did, and they malfunctioned. And really for that third factor, it's adequately respond. So whether they adequately respond.
Let's get over the first two. Did they have advanced knowledge of that? They
Your
didn't
Honor,
know. They didn't. There's no allegation that they knew they were going to be deficient. They thought they were complying.
Your Honor, even if they thought that they were complying, they knew that their efforts were not enough once the devices malfunction. Just because they have one effort of providing two devices is not enough. They also need to adequately respond to ineffective communication. And that's what's important here. Once the second device malfunctioned, they took no further efforts not to provide a third VRI device, not to call an in-person interpreter. There's no allegation.
That doesn't show deliberate indifference. That shows an inability to respond. They didn't have any more machines. I'm sure they would have brought more.
Your Honor, well, there's no allegations whether or not there was any more machines. They had 220, 200. That's not in the face of the complaint. And that's what's important. This is the 12.
You have the burden.
We do have the burden, but on the face of the complaint, there's no allegations from staff members saying, Mr. Basta, we would have provided a third VRI device, but we don't have one. And in fact, Mr. Basta requested an in-person interpreter before arriving to the hospital. He requested an interpreter.
Well, it's in person. This one is a remote person. I mean, it's an interpreter. And you're not challenging the fact that had they had a perfectly working machine with a remote interpreter, that wouldn't have satisfied the act.
It's possible it would not satisfy the act.
Well, let's not get into that. I don't know if you allege it, but there's a regulation that's flat against you on that, you can provide a machine.
No, Your Honor, of course, typically in most circumstances, you could provide VRI so long as it's effective in the circumstances. Paragraph 21 states that the outlet to plug in the VRI device was far away from his wife's bed during the delivery. And so there was allegations that he could not effectively communicate and participate in his wife's birth. But the allegations.
Was this plug-in a receptacle, an electrical receptacle, or is it a different type of plug-in?
It's not alleged, but typically VRI devices have a standard outlet plug. But Your Honor, the allegations of in-person interpreters are important because Novant had advanced knowledge of a need for ASL interpreters and a preference for in-person ASL interpreters. Most importantly, there's no allegations for any attempts to do anything once the second VRI device malfunctioned. No allegations that Novant called a service and said, could you provide an in-person interpreter? And the service told them, we cannot during the 3 days of the hospital admission. That's important. That's important to show that they failed to adequately respond. And that's where the district court got it wrong. There's no need for systematic and pervasive failures or widespread failures when you have information that the defendant entity.
Well, I think you're misconstruing the systematic illusion. The systematic illusion is if you don't have actual knowledge and you had a systematic failure, that imputes knowledge. But the requirement is still knowledge. So if every time they tried these machines in the last month and they failed, then you could argue that was imputes knowledge to them. But the test is pretty clear from Kuhn, and Kuhn restates others. If we have the deliberate indifference standard, that's not even a sure thing, because the question is whether that satisfies intentional discrimination. But let's assume we're under that for the point that you've alleged that. And it seems to me the two big elements you have is you have to show that the hospital knew that their machines were likely to fail and did nothing about it. And of course, if they had a systemic failure, that would be imputed knowledge. But they don't need systemic failure, but they still have to have that knowledge. And you haven't alleged that.
Your Honor, two responses to that. First, we have alleged that they have the knowledge that their VRI devices would provide ineffective communication. It doesn't have to be in advance. We see here in the delivery room, the VRI devices were malfunctioning, and then Novant took no further steps. Second, to address—
They got another machine. They pulled the one out. They thought it was malfunctioning, put another one in, and they obviously recognized their responsibility. They obviously tried to take care of it. They assured you they were going to do it. This is not a situation.
Counsel, let me ask a question of you. It seems to me that your interesting dialogue with Judge Niemeyer as to what they might have done or what they could have. I thought the strongest point in your case was that this was all thrown out on a 12B6. And so we have to take everything that you say as true. But isn't this a close enough case that it would be good to learn a little bit more about it and get the hospital's point of view and get your point of view? In other words, normally an immunity is most effective if it's granted at the beginning. But what I wonder is whether this has enough factual uncertainty to it and is pretty darn close. Knocking it out on 12B6 seems to me a little bit premature. I think it would profit everybody to know more than we can just glean from the pleading. I mean, I'm not sure how it'll end up, but the question here is whether you plausibly pled a violation. And I read through this, and I, just want to know what you requested and what the hospital did and what knowledge the hospital had and all the rest. But what do you think about that? Do you think we need some more development of this?
Yes, Judge Wilkinson, I absolutely do. And I do see that my time is up. Can I respond further to you and briefly conclude?
Why don't you save that? You've got some rebuttal time. Why don't you save it for that point unless my colleagues have questions? Right. Thank you. Let's hear from the government here. You're welcome to wear your mask when you're arguing, but you're not required to.
Thank you, Judge Wilkinson. May it please the court, Noah Bocat-Lindell for the United States. I'd like to start with one of the comments that Judge Niemeyer made earlier, that these sort of systemic and pervasive problems requirement that the district court came up with is a way of imputing knowledge, but that it's not actually necessary if there is actual knowledge. And we very much agree with that. And that is the key issue here with what the district court got wrong. The problem here is that after these two VRI machines malfunctioned, the allegations in the complaint are that Mr. Basta made repeated additional requests for an interpreter. And those additional requests put the hospital on notice that the VRI machines it had provided were not enough to provide effective communication to Mr. Basta. And at that point, they had a duty to investigate what needs Mr. Basta had and how they could deal with that. But the allegations are that they did absolutely nothing at that point for the remaining 2+ days of the hospital stay. They did not provide any form of auxiliary aid whatsoever. And for this, we would point to the Bax case from the Ninth Circuit that the defendants put in on a 28J letter here. That case has not been published in the Federal Reporter yet, but at page 8 of the Westlaw version of it, it says, quote, "A request for accommodation rather performs a signaling function. It puts the covered entity on notice of the need for an accommodation." And here, that's precisely what happened. The provision of the VR machines may well have provided the sort of good faith response to the initial requests that Mr. Basta had for an auxiliary aid. But once Mr. Basta made those additional requests throughout the remainder of his stay at the hospital, they were put on notice that further auxiliary aids were necessary because those VRI machines were not working. And at that point, they had actual notice under the Kuhn standard, and they were required to provide effective auxiliary aids, or at least provide a good faith response at that point. And again, the allegations are that they did nothing.
Where's that allocation? What paragraph?
Sure. So they're at paragraph 26, for example, throughout Mr. Basta's hospitalization from June 2nd through June 4th, 2017, plaintiff made repeated requests for interpreters. Also, paragraph 29 of the complaint specifically says that despite repeated technical issues with the VRI and Mr. Basta's resulting requests for an in-person interpreter, defendant staff failed to provide an interpreter or an effective alternative auxiliary aid to plaintiff. So there, the allegations are that after the—
Is there any suggestion that the hospital had the capacity to do so at that point?
No, Your Honor, but again, this is where the procedural posture of this case is important. We're here on a 12B6 motion. All we have are the four corners of the complaint, and based on the allegations in the complaint read favorably toward Mr. Basta, the allegations are that they did not investigate his communication needs. They did not provide any form of auxiliary aid. So the question is not just whether they had an additional VRI machine, but whether they provided any effective form of communication for Mr. Basta. And again, that could have been an in-person interpreter. It could have been another VRI machine. It could have been—
They may be, these are failures and they may be negligence. But my question is, it seems to me all the allegations point to the fact that they were not deliberately indifferent to his needs. To the contrary, they recognized his needs and provided a machine and said, we'll take care of it. And then when that machine failed, they provided another machine. But they never said, we're not going to provide a machine. Basically, their machines failed. It was an unfortunate thing, but we're talking about this deliberate indifference, and you're talking about sort of a negligent failure to provide. They didn't thumb their nose. Deliberate indifference is sort of thumbing your nose at the requirement. They didn't do that. Basically, they failed to do it. That's the allegation. But they tried. And so that doesn't show deliberate intentional discrimination. It shows maybe their machines hadn't been serviced or whatever their failure was, but they clearly recognized their responsibility and tried to do it. They failed though.
But let me ask you, I'm sorry.
You go ahead. No, I'm fine.
Wouldn't part of the hospital's responsibility to be, when they get a request and have the knowledge that a person's coming in with this disability, one, make sure the machines work, make sure they can accommodate the victim, make sure they can provide the services that are needed and required by law?
Yes, Your Honor, that is their requirement under the regulations, 45 CFR 84.52.
So the way, if I look at this complaint, it says to me, they were notified that this person's coming in with a disability and nothing worked. Nothing was provided. He got no service.
That's right, Your Honor. And that certainly is enough to show deliberate indifference. But even if you were to look more narrowly, as Judge Niemeyer is pointing out, looking at those provision of those VRI machines, even if one were to assume that that is an initial good faith response, the right way to think about this is that that essentially resets the deliberate indifference.
But I don't even know why you want to presume that. I mean, what if it seems to me it would have been expected and as part of their duty to check the machines before they're depended on to make sure they work. Of course, we don't know that yet. All we know is the request was made and nothing got done.
That's right, Your Honor.
Nothing, not even something got done, but I mean, no service was provided.
That's right, Your Honor. And I think as a parallel case to look at would be the Sunderland case in the 11th Circuit, which the district court discussed. And in that case, the court went through several different plaintiffs and their specific hospital stays and what was going on with them. And in that case, the named plaintiff, Ms. Sunderland, came in and requested an interpreter, which the 11th Circuit said put the hospital on notice that she required an auxiliary aid. They initially didn't provide her with anything. Eventually, after she had surgery, they provided her with a VRI machine, just as VRI machines were provided to Mr. Basta here. But just as the VRI machines here allegedly malfunctioned, there, the VRI machine also malfunctioned and froze and didn't allow her to.
Your basic point, to follow up on Judge Traxler's point, is that the district court analyzed this under an incorrect standard. And the correct standard is you don't have to have a systematic and pervasive problem. If you have a single individual, as I understand the Rehabilitation Act, if you have a single individual that lets the hospital know beforehand that I have a disability, I'm going to need an interpreter, and the hospital is put on notice of all of that and it fails to respond, even though that's a single incident, it would still be cognizable under the Rehabilitation Act if the hospital's conduct was one of being notified for something and doing nothing, or at least the bare minimum. But we look at this through the eyes of a single individual, and you can fail to accommodate a single individual. You don't have to have systemic deliberate indifference. It's enough if you are aware of a single individual's plight, which here was quite serious. He wanted to be able to communicate his wife's disability to the doctors. I mean, it doesn't get more basic than that. And the regs under the rehabilitation provide that for the accommodation of a companion, because a lot of people, when they go into the hospital, they can't fend for themselves. They're either too sick to do it or they have language problems or whatever. And if they bring someone into a system, the hospital has to do something about that if they're notified of it. And you look at this from each individual patient, not from a systemic point of view. And I think the district court has to review it under the proper Rehabilitation Act standard, which was the problem here. You've got a very serious situation where somebody is in childbirth and the one person who knows about her difficulties and everything and can alert the hospital to it, is not able to understand or communicate with the hospital in any way. And that leaves her bereft completely. And that's not where I understand the Rehabilitation Act is going.
That's correct, Your Honor. I think that individualized analysis is required by the language of the statute, which is individually focused. All of the precedent on this, whether you look at a case like Sunderland, a case like the Lease case from the 11th Circuit, Loeffler from the 2nd Circuit, all of these cases involve individual hospital stays with individual problems where they were not given proper auxiliary aids. That's correct. And for those reasons, Your Honor, we ask that you reverse the district court.
Mr. Stevens, be happy to hear from you, sir.
Good morning, Your Honors. May it please the court, counsel, my name is David Stevens. I represent the Applee Novant Health, Inc. and its affiliated entities, which are the defendants in the underlying lawsuit. A well-pleaded complaint tells a story. And under federal pleading standards, that story must provide enough facts to show that the plaintiff is plausibly entitled to the relief that he seeks. The operative complaint in this case doesn't do that. Instead, it tells a very narrow story that when its allegations are read in their collective whole, doesn't make out a violation of the law. Paragraph 1 of the complaint says it all. Quote, by ignoring or denying plaintiff's requests for qualified in-person interpreters, defendants failed to ensure effective communication. The story of this complaint is about a person who wanted a live interpreter and didn't get one. That's it. And that's not enough to state a claim under the Rehabilitation Act and the Affordable Care Act. When this court affirmed the decision.
Excuse me, counsel, but the Rehabilitation Act talks about a need to accommodate persons with impaired hearing or vision. And doesn't that include companions with a disability as well as the patients, because the Rehabilitation Act reaches companions?
Yes, it does, Your Honor. And we did not contest at the district court or on this appeal that Mr. Basta, as a companion, was entitled to accommodation under the Rehabilitation Act.
Or you can see that. And you can see that the Rehabilitation Act extends to companions with a disability as well as with patients.
Yes, Your Honor. The Rehabilitation Act extends to companions as well as patients with disabilities.
Well, then why, if an individual's rights are infringed under the statute, why wouldn't that be cognizable? If in light of what you have said, that the Rehabilitation Act extends to persons with impaired vision or impaired hearing, and that the disability includes companions as well as patients, how can it possibly be said that if the act is violated, we can just shrug it off by saying, oh, well, the violation just affected one person, no problem. If deliberate indifference, if we found deliberate indifference here, how can we just shrug it off by saying, oh, well, it was just one person? Because and we have individual plaintiffs bringing actions under the Rehabilitation Act and under all kinds of statutes, asserting their individual rights, not systemic failures or whatever. And we've never said when an individual brings an action, we're going to toss you out of court because there's no systemic failure, which is what the district court was a very fine district judge. I have great respect for him, and we share that. But I just don't think if we get to the point of saying that none of these statutes are violated because there's no systemic or pervasive problem, then what happens to the individual plaintiff who suffered a violation? See, it seems to me that this is such a path-breaking theory, this traveling in exactly the wrong direction. I prefer really to see individual claims brought as opposed to class actions. I like them brought on an individual basis. But I'm concerned about where you're going with the fundamental right of the single individual to assert a right under one of these civil rights statutes. Doesn't make sense.
I understand the point that you're making, Judge Wilkinson, but again, when we talk about a systemic or pervasive issue, I think that what even Judge Conrad said at the court below is you're looking at systemic, pervasive, and known, and whether or not the entity or the individual at the entity knew of the suspected violation and failed to act on it. The counsel, I believe for the government, referred to the Sunderland case. In the Sunderland case, that individual complained about the non-working VRI devices. When we look at the underlying complaint in this case, there is no indication after paragraph 21 of the complaint that Mr. Basta ever complained the second VRI device didn't work. The complaint only says the first VRI device didn't work. It was swapped out.
Well, this goes to the need to develop the evidence further under the proper standard. What you just said is a good point, but it's a point that needs to be made by you in the course of the further development of the evidence in light of the correct standard. But that's a discovery point or a summary judgment point or conceivably a jury point. It's not a point for tossing it out, it seems to me, under 12b-6.
Well, your point is taken, Judge. But in fact, the plaintiff's complaint in paragraph 28 makes it clear that Mr. Basta did not complain about the non-working VRI devices until June 11th, 2017, a week after his wife was.
Is it your position that the disabled person has a duty to tell you multiple times that he has a problem, what his disability is and what his needs are?
That is not my position, Judge, but
why do you say he has a responsibility to complain more?
Well, because I don't think that this complaint anywhere alleges that he once complained that the second VRI device didn't work.
But you agree he doesn't have to. He's already told you once. He's already written, you've acknowledged it. You provided two machines, whether you knew they worked or not. That's, like Judge Wilkinson says, a matter for discovery. But you seem to be saying he's got, in order to maintain his rights, he has to tell you multiple times of what his disability is and what his needs are.
No, and respectfully, Judge, that's not the point that I'm trying to make. The point that I'm trying to make is that simply saying I want a live in-person interpreter is not a corollary for the second VRI device that you gave me is not working. And if the individual does not report that the second VRI device isn't working, then there's no way that the hospital can be on notice that the accommodation offered to this individual was insufficient. And
wait, say that again. The hospital is not on notice that there's a problem. Say that again. I don't want to misstate your position.
in paragraph 20 of the complaint, it's alleged that a first VRI device was given to Mr. Basta. It was blurry, choppy, and failed to provide effective communication. In paragraph 21 of the complaint, it says a second VRI device was given to Mr. Basta, and it alleges that that VRI device was blurry, choppy, and failed to give effective communication. A reasonable inference from paragraphs 20 to 21 is that Mr. Basta told somebody or the hospital knew that that first VRI device did.
Say that again.
A reasonable inference from paragraph 20 to 21 is that Mr. Basta told someone or the hospital knew that that first VRI didn't work.
Is that a reasonable inference in favor of the plaintiff, which is our requirement?
I think that that's a reasonable inference in favor of the hospital.
Well, but that's not the 12B6 motion, 12B6 standard.
But I also think that a reasonable inference from this complaint is that after paragraph 21, there's no indication that Mr. Basta said, this second device you gave me doesn't work.
And so you think he had a responsibility then to tell you his needs have been satisfied, or he doesn't care anymore, or he doesn't worry about his wife and child?
Well, Judge, I believe that he has a responsibility to say, I am not receiving effective communication from this device. I would like something else.
You think that wasn't common knowledge? It doesn't work.
I don't.
To everybody, I mean, everybody that sees it knows it doesn't work.
I don't think that the complaint alleges that everyone who saw him knows that it didn't work.
They
There's no
don't-
allegation that the plaintiff said anything or that anyone at Novant observed or saw the failures of the device.
Thank you.
Going back to this court's decision in Kuhn versus North Carolina just a few weeks ago, again, deliberate indifference is a very high bar. In order to clear that bar, a plaintiff is going to have to show that there was actual notice by the defendant. And again, when we look at this, the full allegations in this complaint, there is nothing in this complaint that says that Mr. Basta put Novant on notice that the second VRI device was failing. As to another point that we made in our briefing,
How do you address the fact that the complaint alleged that both machines were malfunctioning?
I don't think that there's, at least accepting all of the allegations pleaded in the complaint is true. Obviously, we have to take as a matter of record that the second device was in fact not working.
Well, he alleged that.
That's correct, but he
So
doesn't
now the
allege that we
question-
knew it wasn't.
Well, if they plug it in, it's not, it's, why did they replace the first?
Ostensibly, I think the inference could be made that there was some knowledge that the first one didn't work, and that shows that.
Yeah,
Novant
but
was
when
not
they plug
deliberately
in the
indifferent.
second one, and they plug it in and look, and the same image comes up, it's blurry and choppy. Everybody's standing around right after they plug it in, it comes on, you can't see anything. That seems to be hardly a good argument.
But the argument that Mr. Basta's counsel made at the court below is that for a very short period of time, the VRI device was blurry and choppy. And the predominating complaint about the second VRI device was that it needed to be plugged into the wall and was too far from his wife's bed.
Well, he said that in addition, and he also said that he preferred in person, but I'm just addressing your argument that there's no suggestion that he complained about the two machines malfunctioning. I thought he did.
To be clear, Your Honor, my argument is that he did not complain about the second machine malfunction.
Well, he alleged they were both. He alleged that both machines didn't work, and it seems to me when they plug in the second one and it has the same symptoms. Who plugged it in? He didn't plug it in, did he? The staff plugged it in.
I don't believe that the complaint has any allegations as to who plugged it in, but the complaint
They
certainly
didn't
has.
just deliver it on the front door. That's stick it in the hall and say, patient, go find that thing in the hall and plug it in yourself.
I don't believe there's
you
any.
may have good arguments, but I think it's what you're arguing is almost frivolous.
Well, what we're arguing, Your Honor, is whether or not Novant had any actual notice of the fact that harm was substantially likely to occur.
Well, I think that's the issue in the case, and there you make a much more forceful argument. In other words, was the hospital ignoring its responsibility and ignoring the fact that the machine didn't work after having knowledge of it. And they clearly didn't have, there's no allegation they had advanced knowledge about the two machines going bad. And it seems to me the deliberate indifference is intended to provide the mens rea for intentional discrimination. And so the question is, did the hospital intentionally discriminate against this man, or were they trying to comply and fail to do so, albeit negligently?
I think, and I agree with you, Your Honor. I think that that is the issue that's set out in this case, which is, was there foreknowledge that there may be an issue with the VRI device in advance? And if there was that foreknowledge, then certainly there's a possibility that that could lead to a finding of deliberate indifference. But even if there were systematic and pervasive issues with the
Why
VRI
do you
device,
go back to systematic? I mean, there's no suggestion one way or the other. The systematic is an alternative for providing knowledge. In other words, if you've had the prior week, you had the machines that didn't work, it seems to me at that point, you may be on knowledge that the machines don't work and you're going to have to check them out. But you deliberately ignored that. But that's not the allegation in this case. Systematic's irrelevant in this case. What's the question in this case? I think the question in this case is whether after the hospital provided two machines, can you base a claim on the failure to provide a third machine or get an interpreter when, and the answer might be they didn't do it clearly. They didn't provide them with any mechanism for communicating. The question is, was that the product of deliberate intentional discrimination, or was it just a negligent failure?
correct. I agree with you, Judge. And that brings us back to the Kuhn case as to whether or not Novant was on notice that the second device wasn't working. And paragraph 28 of the complaint does quite clearly say that Mr. Basta did not complain about the non-working VRI device until June 11th. So it would be impossible for Novant to have been on notice that the second VRI device wasn't working if he did not raise his hand and say, "You've provided me something that's broken and isn't working." There's
But
nothing.
Didn't he continue to ask for an interpreter after the second machine?
He did, Your Honor. That's alleged in the complaint. And again, I don't know whether accepting all of the well-pleaded facts in the complaint is true. He alleges that on multiple occasions after his wife gave birth on the first day, he asked for a live in-person interpreter. That draws us back to the Godby versus Iredell Memorial Hospital case, which is to say that simply asking for a live interpreter isn't enough to put an entity on notice that some other accommodation isn't working.
Let me switch gears on you just a second. You're familiar, I'm sure, with this statement in the district court's order that there must be a systemic and pervasive problem that such must exist in order to succeed in proving intentional discrimination. Do you agree that's an accurate statement of the law? Is it your position that's an accurate statement of the law?
I would slightly modify that to say systemic, pervasive, and known.
And what?
Known, and I believe that we say that in our appellate brief, Your Honor,
So
which is a systemic and pervasive problem if not known.
So one incident would never, under any circumstances, be a basis for a successful lawsuit in a showing deliberate indifference.
It must be that the individual or entity accused of discriminating against the individual was aware of the fact that a requested or provided accommodation would fall short.
That's not my question, though. My question is it your position that a single isolated event can never be the basis for a successful lawsuit to show intentional discrimination or deliberate indifference?
No, that's not my position, Your Honor.
So you don't agree that this statement by the district judge is accurate as a statement of law?
As a statement of law, again, I think systemic, pervasive, and known. So what I think we're getting at there, and I believe that Judge Niemeyer pointed that earlier, which is that might be one way to get at this, but that's not true of an individual case.
But it's not the only. It's not the only way.
That is not the only way to get there. We completely agree with that point.
Okay, thank you.
But you agree that was the standard the district court used?
I believe that what
Right, I mean, it's right there in the opinion.
I believe that the district court used the word may in that, which is to say systemic, a court may find deliberate indifference under systemic.
Actually, he didn't say that. He said this theme that systemic and pervasive problems rather than an isolated incident must exist to succeed in showing intentional discrimination.
I believe that what the district court was commenting on there is a long series of cases that were argued and briefed at the district court level, and again briefed here, where there were such issues. But to your question earlier, Judge Traxler, if there's an individual who walks into a hospital, requests a live interpreter, is provided a VRI device, and says to the hospital, this VRI device isn't working, I would like a live interpreter. And a second VRI device is given to that individual, and the individual says to the hospital, this VRI device isn't working, I would like a live interpreter. And the hospital ignores them entirely and does nothing after being placed on notice of repeated failures and timely notice of repeated failures. I believe you can support a finding of deliberate indifference there. But absent the notice, I mean, again, this is an actual notice standard and it's a high bar, that there has to be that element of notice in order for the party on the other side of the communication to understand and engage in conduct that would violate the law. I see that I'm just about out of time, so I don't want to start any more questions or any more issues, but if the court has any further questions, I'd be happy to answer them.
All right, we thank you very much, sir. Appreciate it. Mr. Hammond?
Thank you, Your Honor. I would like to address three main points on rebuttal. One about the 12b6 standard, one about specific portions of the record, and one about viewing the case in the eyes of the individual. Picking up where I left off in the start of my argument, I agree that the 12b6 standard is very important here. We have to draw all well-pleaded allegations and reasonable inferences in favor of Mr. Basta. In fact, there were only two cases that the parties collectively discussed at the 12b6 stage: Esparza from the Western District of Louisiana and Lucky from the Southern District of New York, which were decided on motions to dismiss. Both those cases resolved in favor of the deaf plaintiff. It's important for us to move forward to discovery to understand these fact-intensive issues. Very much so when I had my colloquy with Judge Niemeyer about the amount of VRI devices, the ability to obtain an interpreter, as well as Judge Traxler's comment about whether they had a test run beforehand to make sure whether these devices worked properly. That's all important. That's all information we can glean from discovery. My second and related point is about the record. My friend on the other side made much about the fact that after the second VRI device malfunctioned, there wasn't allegations of any complaints. As a threshold matter, our position is that no complaints are required. However, there are a few important points. First, as my colleague of the government pointed out in paragraph 29, it states, despite repeated technical issues with the VRI and Mr. Basta's resulting requests for an in-person interpreter. So after the second VRI device malfunctioned, he made additional requests.
Earlier, I think you also alleged that both machines were malfunctioning and they didn't provide any interpreters. And the inference from that is that everybody knew there was no service being provided.
I agree, and that's my next point. Is effectively this is an interactive process where mom and dad are trying to make sure they have the safe delivery of the child. Naturally, the hospital staff would be communicating with Mr. Basta during the birth of his child. In addition, in paragraph 22, it states no other auxiliary aids or services were provided to Mr. Basta. So if Novant believed that VRI was functioning properly, there's no indication of why they didn't provide it on the second and third day. And moreover, just one last point about the record that didn't come out. In paragraph 17, it states when Mr. Basta made a request even before the 3-day admission started, it states a member of defendant staff assured Mr. Basta that an in-person ASL interpreter would be procured once Mr. Basta contacted defendants to inform defendants that he and Mrs. Basta were on their way to the medical facility. The reasonable inference here is that they have an ability to procure an in-person interpreter. Obviously, if someone's going to a hospital when they're having contractions, they would require an interpreter fairly quickly. And this allegation and the reasonable inference is that Novant has that ability. Now, third, let me turn to the analysis under the eyes of the individual. Now, my friend on the other side added a word to the district court statements about systemic and pervasive failures, knowing, and that's the only word that matters. It's the operative word, whether they knew, and they did. There's no requirement that they have advance notice or a laundry list of past problems with accommodations. And what's important is once the hospital provides that accommodation, they have a duty to make sure that that accommodation is working properly. And if it is not, they have an obligation to make sure that they provide further accommodations. And that just wasn't the case here. To emphasize, Mr. Basta forever lost the chance to participate in the birth of his child. He also didn't have the opportunity to advise hospital staff about his wife's medical concerns, about her history of blood loss with a prior childbirth, or the fact that she was unconscious during a prior childbirth. He did not and was not able to communicate that information. We have allegations in the complaint that there were requests before he arrived, on his way to the hospital, when he was there, and more specifically, those repeating and resulting requests after VRI malfunction. Given the 12B6 standard, it's important to send this matter back to the district court so the parties can conduct discovery and take depositions and exchange documents to understand exactly what happened here. And if the court has no further questions, I thank you very much for your time. The decision below should be reversed and remanded.
Any further questions from anyone?
Um,
All
I,
right,
Judge Wilkinson, can I ask one quick question?
you sure may.
Is it this is really mostly a matter of curiosity, personal curiosity. Is it your position that I get from reading this complaint that he was assured he would get an interpreter by the hospital?
Yes, specifically the timeline.
I'm looking at 17th paragraph of your complaint.
That's correct. So just to give the quick before part, so he had pre-registered and requested one in advance. Novant said, when you're on the way to the hospital, give us another call. He did so, and once he did, the hospital assured him, as paragraph 17 states, that an in-person ASL interpreter would be procured.
Okay.
Thank you, Your Honors.
Let me ask you one further question. If the machines were working beautifully and had a remote interpreter, would that fulfill the accommodation?
In this case, it would still be a fact issue, again, just because of the proximity of the device and also just given the nature of communication, because
Well,
it's.
I was referring to the Code of Federal Regulations 36.303F, and there they refer to the use of such machines. It seems to me that if it was working well, he would probably not be entitled to have an in-person if he had a remote person.
Of course, I'm not trying to fight the regulation, and I would agree that it would be a very hard case for us if it worked properly. The only point I just wanted to raise, just to make sure I didn't waive it, was just given the nature of the childbirth, of potentially how fast moving and literally moving things could be, that having a screen, and depending on how big the screen is, could be problematic, just depending on where everyone's stationed, if there are multiple nurses, multiple doctors. But I would agree on the whole, if they have a remote interpreter that satisfies the regulations, that in most circumstances, that certainly would provide effective communication. Thank
All
you.
right, thank you very much. We will, when council is ready, we will now proceed into our next case, McCoy versus Hooks.
the court. My name is Jamie Lau, appearing on behalf of Petitioner Lamont McCoy. The issue before this court is whether new evidence not presented at trial make it more likely than not that no reasonable juror would find Mr. McCoy guilty beyond a reasonable doubt. New evidence shows that Myron Haley was shot in another part of Fayetteville, Groveview Terrace, by another person, William Talley. The evidence was first developed during a federal investigation into Fayetteville's Port Boys gangs. Groveview Terrace and Haymont Hill, where McCoy was alleged to have shot Haley, are different locations, and the vehicle containing Haley's body was found down an embankment approximately equidistant from both. The two versions of Haley's murder are irreconcilable, and no reasonable juror would convict McCoy on the facts before this court. That the actual innocence standard is met here is supported by evidence that would make any reasonable juror doubt the state's case. The Fayetteville Police Department's Special Response Unit was present at the very location and time that the state alleged McCoy committed the murder. This evidence renders the state's case at trial impossible, and any juror hearing it would have doubt given that the state's case relied on a single witness with no physical evidence. Additionally, it is now known that the state suppressed information identifying another individual, William Talley, as the perpetrator. And the record shows that 10 people now, including 2 who have testified under oath in federal court, sharing a consistent account of Talley, not McCoy, shooting Haley. The remarkable thing is that the state, knowing that Talley was identified.
Can I go back? Was the information that the officers were at that location, was that available at the time of trial, or when? How did that come up?
Well, 2 things, Your Honor. First, it was not presented at trial, and the standard by this court under Finch is whether or not, for new evidence, is whether or not it was evidence presented at trial. However, it was not known to counsel that the Special Response Unit from the Fayetteville Police Department had went to the scene on Branson and Bryant Street in Haymont Hill, where Mr. McCoy is alleged to have committed the crime, and was there till at least 12:41 a.m. on January 26, 1990. There was people from Haymont Hill who said that police officers had went up to that area after an earlier shooting that night that took out a transformer, but there was no indication from those people that were spoken with regards to just how long the police were present up there. Additionally,
when's the best evidence about the placement of the time of the murder in this case?
well, the witness that testified with regards to the placement of time is an individual named Bobby Williams. And he testified that on the night of January 25th, he anchored his testimony to the night of January 25th because he knew he was doing court-mandated community service that night. He came home from his court-mandated community service, and after that, took a shower and went out. He then testifies that he spoke with an individual named Lonnie McNeil, and that while he was talking to Mr. McNeil, Myron Haley walked up and told him that he was looking for an individual who had been involved in a drug transaction. And they walked to the arcade, went inside, very explicitly stated, they went inside that arcade, looked
That
around.
discredits him. I know all about that. In other words, the arcade had closed because of power outage and that type of thing. But I'm trying to figure out, how do we place the timing? That witness had, you pointed out a lot of problems with that witness.
The best evidence we have of the timing is what was testified to at trial. And what was testified to at trial was that this occurred on the night of January 25th. It's ubiquitous throughout trial. The police felony investigative report that was completed by Detective Ballard, who also testified at trial, said that the crime occurred between 11 p.m. and 12 a.m. on the night of January 25th. So every indication.
Is that the only evidence of when the murder was committed at trial? I'm asking this basically to see how relevant it is, whether the officers were there. In other words, that subsequent testimony, evidence that the officers were actually at that point. If the murder was committed, obviously at 2 o'clock or 1 o'clock in the morning, then that would be irrelevant. But
well, this court has to view the totality of evidence and how a reasonable juror would react to the totality of evidence. And you just point out that the state's lone witness in the case has a host of problems. But the state's case at trial, the record, when you look at
how does the state's witness have a host of problems? I don't understand that, because he all the past misdeeds that you complain about on witnesses on Williams' part and the criminal record of Williams, that was all before the jury. And he passed a polygraph and he was still found credible. And there were other witnesses that supported his account. And you have Charles Williams Jr. and I don't know what the other person's name is. Kibby Johnson
Well,
supported Mr. Williams' account, and or you know you can always find after trial some kind of additional evidence here and there, but it seems to me that
Judge Wilkinson,
we're reducing the role of the state jury, and we are reducing the role of the state Supreme Court, and we're reducing the role of the federal evidentiary hearing and everything in a case where we should be the very last ones to be overturning these kinds of jury verdicts that have been through round after round after round of review.
Judge Wilkinson, I submit to you, we're not reducing those roles. We're doing precisely what the court asked this court to do in Supreme Court precedent in Schlupp versus Dello that was reaffirmed in 2013 in McQuiggan versus Perkins. And that is to look at the collective evidence, the totality of evidence available to us present day, and to determine what a probabilistic determination of what a reasonable juror would do in light of that evidence. That didn't happen at the magistrate in the court below here, and it never happened at the state level. The magistrate judge, if you're wondering with regards to the problems with Mr. Williams himself, identifies a whole host of problems with his testimony in the magistrate's opinion recommendation on 2363 through 2369 in the joint appendix. So there's a lot. And with regards to those other witnesses you spoke about, Charles Williams, Kibby Johnson, the first thing with regards to Charles Williams is he originally told law enforcement that all he knew about the case, he learned from the papers, and he asked law enforcement to come see him to help him while he was in the Sampson County Jail. And only later did his statement suggest to support Williams, but also it was deeply problematic because it placed it on January 25th around 9 p.m. at the very time we know that it's impossible that Haley was being killed on Haymont Hill. Kibby Johnson was originally approached by Detective Ballard. Detective Ballard told him he needed to speak with him, people needed to start talking, or he was going to shut the drug trade down on the corner that Kibby Johnson was dealing drugs, presumably. And he first told him that Dennis Fort was the one that he saw shooting on the night of January 25th. 1990, not the account that later appears in Detective Ballard's felony investigative report. But all that evidence has to be weighed against the credible evidence from the federal task force investigation with regards to William Talley and William Talley shooting Haley on the night of January 25th, 1990. And I want to point out, this is where the state court proceedings went awry, went off the tracks. The state court proceedings went off the tracks because during the first motion for appropriate relief that was filed by Mr. McCoy, the state argued that the only thing that the evidence from the court poison investigation indicated was that another shooting occurred at some unknown time in Fayetteville, North Carolina. That was the state's argument. The state's, and you can see that on the joint appendix 690. What's deeply problematic, and I hope concerns this court, is at the time that the state is making that argument, it has in its possession undisclosed tips that it received from January 27th, the day after Myron Haley was found deceased, and January 28th, indicating that William Talley was the person responsible for Haley's death. The tips were a timestamp to show the state court that these were the same shootings that were being discussed. And those tips were only first revealed in 2018, after the conclusion of all the state court proceedings. And the last point I want to make goes to the state Supreme Court. The state Supreme Court has never weighed in on this evidence, this new evidence. The state Supreme Court, like cited by the magistrate's recommendation, that says that the state Supreme Court can give credit to that a jury. It doesn't say that statements Mr. McCoy made amounted to incriminating statements. It says that there was sufficient evidence that a jury could conclude that. That state Supreme Court decision cited was on direct appeal before any of this new evidence that now shows that William Talley was the person responsible.
Well, fine, you have an MAR court for that, and you have the magistrate judge in the federal system for that. They looked at all of this. I mean, there are very few cases that there's not some after discovered evidence. It's always brought up. And I thought that EDPA was passed to shut off these kind of claims because they just go on, and the Supreme Court makes schlup, which is what you're proceeding under. They emphasize that it's a very high bar. You have to say no reasonable jury could have voted to convict. And given Ballard's statement, the officer's statement that this individual confessed, that McCoy confessed with a smirk on his face and a smile on his face, and given Williams's testimony and the attacks that were made on it, that eventually failed to persuade the jury of any kind of innocence, and some of McCoy's own witnesses in the federal evidentiary hearing undermined his case, and trying to prove that with this evidence that no reasonable juror could have voted to convict, that's an awfully high standard. That's about as, it's no reasonable juror could have voted to convict on that. Even if they found Williams to be credible, even if they found Ballard to be credible, even if they found the circumstantial evidence to be significant. How can we say that?
Your Honor, if I may, what I'm asking this court to do is to have fidelity to the guidance that the Supreme Court has provided. The Supreme Court has said in these actual innocence gateway cases that the obligation of the court is to take into consideration all the evidence, old and new, without regard to admissibility, and make a probabilistic determination of what a jury would do. Now, you mentioned that this is a high standard. The Supreme Court does, in fact, say that it expects it to be the rare case where the actual innocence gateway applies. But I submit to you that there's a higher standard at play here. And it's the standard that the jury was asked to apply at trial without the benefit of all this other evidence that we now know of today, the credible court voice testimony. And you can find that standard in the joint appendix at 1759, when the jury was told that to find Mr. McCoy guilty by proof beyond a reasonable doubt, they have to have proof that fully satisfies or entirely convinces you of the defendant's guilt. Now, I submit to this court emphatically that in light of the evidence that the federal investigators derived, indicating that William Talley was responsible for Haley's death, a reasonable juror giving consideration to that evidence could not fully satisfy themselves of Mr. McCoy's guilt when the only evidence that the state can present against him is evidence from Bobby Williams. The other individuals that support him, as we mentioned, we described in our reply brief, were deeply problematic and unreliable. But
let me ask you about the confessions, because it seems to me the state's case really centered on one witness and the confessions. The one witness, we can talk about that, but that's fairly complex. But the confessions, tell me how that was the jury given the question whether that those were confessions, or it looked to me like the attorney may have said that he confessed and was arguing for manslaughter or something. And the instruction to the jury was that he had confessed, which didn't leave the issue for the jury to decide, especially in a case where the dialogue on that confession is sort of unique. He says, I know it, I know it, I know it, I know it, to various questions, as if he's saying jury could have concluded saying, I know, I hear you, as opposed to confessing to a crime. So I want to know, was the jury presented with the question of whether he confessed?
The jury was, the statement that Mr. McCoy was said to have given to Ballard, the remarks of I know it were presented by testimony from Ballard. The jury was then charged that there is evidence tending to show that the defendant has admitted facts with respect to the crime, tended to show. So it was still up
What
to
did
the
the
jury.
attorney say to the jury when he argued for manslaughter?
When the attorney argued for manslaughter,
Attorney for McCoy.
he said that, and I don't have the exact words, but something to the effect that the jury could conclude this lesser charge, but he didn't ever acknowledge a confession on the part of Mr. McCoy himself. These remarks don't amount to a confession. They're not explicit with regards to any sort of admission of criminal conduct. And the jury was also asked through its charge to consider all the circumstances to decide what weight to afford the statement of Mr. McCoy, and that was unavailable to the jury. All these circumstances were unavailable to the jury. The credible evidence that Callie shot Haley would prevent any reasonable juror from concluding that that statement amounted to what the state now holds it up to be, a confession. And with that, my time is up. I will reserve 4 minutes.
Thank you.
Thank
Thank you very much. Ms. Callahan?
May it please the court. My name is Kimberly Callahan, Special Deputy Attorney General for the North Carolina Department of Justice, and I represent the respondent in this matter. The actual innocence gateway should open only for rare and truly extraordinary cases, and this is not one of them. Lamont McCoy was a known drug dealer who had a violent reputation for shooting at cars and cheating people out of money by selling them counterfeit drugs.
Could you lower your microphone just a tiny bit so that it's, okay,
Yes.
that's perfect. Thank you, that's perfect.
McCoy made incriminating remarks to Detective Ballard that can be reasonably construed as a direct admission to his involvement in the murder of Myron Haley.
You know, that to me was pretty heavy evidence relied on by the state during the trial.
Yes, Your Honor.
If that evidence had not come in, basically the conviction would have rested on the testimony of Williams, right?
That's correct, Your Honor, yes.
So if we're looking at the assessment of this case in view of the tally information, the late coming tally information, and the possible removal of that confession, it would be a different case, wouldn't it?
I still believe that the case would have.
You think with all that tally information and the test and the holes in Williams' testimony, the jury would have convicted him?
Well, Your Honor, I'd like to talk about that.
Well, I'm
as
trying to
Judge
focus
will-
on the confession.
Okay.
Because the confession, I think, was the manner by which the state carried the case. And it's a peculiar dialogue. And I'm not sure the person who asked the question, who was Ballard?
Detective
asked the
Ballard, yes,
question,
Your Honor.
yeah. Detective Ballard asked those questions, but he never wrote that down as a confession. He never made notes of that or anything, did he?
But he did, Your Honor. It's in his felony investigative report.
That he confessed?
Not that he confessed, but
No.
his,
I know.
the admissions
Yeah.
that I know it.
And how was it treated at trial? Did that jury instruction that was presented to the jury, what was that instruction?
It was an admissions instruction, but it ultimately.
What did it say? Roughly?
That there were facts that he admitted to being involved in this crime, something to that extent, Your Honor.
Didn't he write, he said the judge charged that tends to show. In
Tends
other
to
words, obviously he can't charge that the guy confessed.
Correct. So it was ultimately left up to the jury to determine whether or not they believed that these statements, not only his statement, but his demeanor, and in the context of what was going on here.
I'll tell you what my reaction was to that and reading that is, number one, I know it is not quite saying I did it. And he said the very same word to every question. And there were different questions, about 4 of them, or maybe 5 of them. And he says, I know it, I know it, I know it. He didn't say I did it. He said, I know it. And it came across to me, if somebody were doing this colloquially, that he more likely was saying, I hear you, I hear you, I hear you. I know, I know, I know. The words were exactly, I know it, I know it, I know it. But he used the very same response to every question. And then there was no follow-up, and he never articulated any facts himself about what he did and how he did it.
It's up to the jury to assign weight to that, isn't it, counsel? I mean, the jury can assign what weight to it they want. And my friend's arguments are good arguments, but they're good arguments to be made as a counter argument on the part of the defense at trial.
That's correct.
Whatever interaction there was between Ballard and McCoy was before the jury. They knew there was the testimony as to that, and that could have been tested. But the body in the final analysis that assigns proper weight to that's got to be a jury function, if anything is.
Yes, Your Honor. And I think it's important to know that he was saying, I know it, in the context of being accused of previously shooting at vehicles and being the shooter in this case. And he was saying, I know it, and smirking. And his demeanor changed very quickly when he tried to test Detective Ballard and say, well, what kind of bullet is it? And he rightfully said a .357 Magnum. His demeanor immediately changed and he got out of the vehicle. So I think you have to take all of that in the context. It's not just his response, but it's the change in his demeanor. Detective Ballard testified that he believed at the trial and at the federal evidentiary hearing that he believed that this was an admission of guilt. And the magistrate judge and the district court credited that testimony. And so at this point, the petitioner has to show by clear and convincing evidence that wasn't an admission. And the only thing he has come up with is, well, I was just, smarting off.
How do you take the evidence presented by the federal task force?
I'm sorry, could you repeat your
question? How do you assess, how do you dismiss the evidence presented by the task force that Talley did?
Well, Your Honor, because the Talley evidence for the 2 people that testified at the federal trial could not name the date or the time at when this occurred.
I'm talking about the federal task force. They did an investigation and concluded that Talley had done the shooting. And that's
they did not.
It's late, and they had about 10 people sort of confirm that.
I would take issue with that.
Okay, that's what I want to hear. That's what I want to hear.
Sure. Task force turned over information to the ADA in this case. They said, this is what we have found through our investigation. We believe that there could be some information. The assistant U.S. attorney wrote a letter to the district attorney and said, here's all the information that we have. I don't believe it is enough to exonerate Lamont McCoy or to implicate Talley. There are problems with the Talley evidence. As I said, the 2 persons who testified couldn't name the date. They couldn't even name the year. Both of these locations are known for shootings nearly every single day. They couldn't name the victim. And so you have that evidence on one hand, and the magistrate and the district court said, well, it's a plausible theory, but there's more evidence in the record that supports Williams' eyewitness testimony and McCoy's admissions to Detective Ballard. You have Charles Williams, who did not say it happened at 9 o'clock. He said it happened between 11 and he saw them standing on the corner around 11 or 12. And that approximately 30 minutes later, he heard gunshots and saw them running after a car. You have Kibby Johnson, who also made a statement that was virtually indistinguishable from Williams' account. You have one of the co-defendants, Charmaine Evans, who also gives an account that was virtually indistinguishable from Williams' eyewitness testimony and stated that it was after the police had left the scene from the earlier shooting that was done by Dennis Forte and the boys that ran in his gang. I want to go back to the best evidence of the timeline of the murder in this case. The only timeline that was put before the jury was Williams' testimony that this occurred sometime after the lights came back on. And we know from
Well, I
testimony.
thought there was testimony, an officer placed it between 11 and 11 p.m. and midnight.
That's in his felony investigation report. I don't believe.
Was that was presented at trial?
No, Your Honor. No. The only evidence that was presented at trial was Williams' testimony that this occurred sometimes after the lights came back on.
When the lights come back on?
11:15 and 11:30. So it happened sometime after that. We don't know a definitive timeline of when these events came into motion. So it is very possible that this occurred after 12:41 and the police left the scene. And that was confirmed, even though it was a recanted statement, that was confirmed by one of the co-defendants in this case.
But if you read Bobby Williams' testimony, there's no way if his time, not if his times are correct, but if he did only what he said he did, that would put it between 11 and 12. Isn't that right? I mean, he said he got off work, he went home, he took a shower, maybe ate dinner, and then went out, ran into the victim, and then all this happened. So, I mean, that obviously, presuming he got off work at 5 or 6 or 7 or whatever time it is you can't follow that timeline and those things and then put the shooting 2 or 3 or 4 o'clock in the morning.
Well, we haven't ever put it at 4 or 5 o'clock in the morning. It was
Well,
always the
3:30.
only timeline that the state has ever relied on is sometime after the lights had come back on. And like, as you said, we don't know a precise timeline of what he did when he got home. He said he was talking to his friends. We don't know when he encountered Mr. Haley. And then they went and walked down to the arcade. Just one question about that, or one point about that. Detective Ballard testified that even though the arcade may have closed at 9:30 p.m. because the lights went out, that there were people who frequented that spot because it was a known area for.
But they said they saw people inside that saw him shooting.
And he said he went inside.
He did.
And
Detective Ballard said that it would not be uncommon for people to be inside of that store and that he had interviewed some people. He didn't identify them, but he had interviewed some people that said they went into that store after the lights had gone out. So it is not an impossibility that they did walk down to the arcade after the lights came back on, saw some people down there doing whatever they were doing. It was a known place for drug activity. So that does not make his version of events improbable. It simply doesn't. As for, problems with the host of problems with Mr. Williams, as alleged by opposing counsel, as Judge Wilkerson pointed out, they heard all of this testimony about his criminal past, about his previous drug
Let me
use.
ask you that. I understand all that. And if we were left with just assessing the evidence, it would be fairly straightforward. It made it more complex by the fact that we have this fairly coherent body of evidence that came in later relating to Tally. And then you go back and place that in juxtaposition with the evidence that was used to convict. And it seems to me it was basically the testimony of Williams and the confessions, and which is not for a murder case. Maybe it's enough for the jury, but he protests and thinks he was wrongly convicted. And then all of a sudden, we have all this evidence that this investigation and a lot of people supporting and corroborating this investigation indicated it was Tally. And that all makes a pretty coherent story. It changes. Then you start looking back at the original trial, say you put all that together, how would a jury reacted? And I must say the most troubling part for me, both going either way, is what's purported to be a confession. I've never seen a confession like that. I mean, usually ask him to say, usually sign a document, I did it, and all kinds of other things. But basically, the confession consists of about 4 or 5 statements of I know it, I know it, I know it, I know it, and that ends it. And Ballard didn't go back and say, "Oh, he confessed" or anything. I know.
The strength of that interaction came before the jury, and the jury could assign to it what weight they wanted. But the interaction between Ballard and McCoy was before the jury with all of its strengths and weaknesses, and it's up to the jury to make a judgment on it and ascribe it possible whatever weight it deserves.
Yes, Your Honor. And I'd like to also make a point that was up to the jury, and also the jury credited Williams.
Well, I agree. I don't disagree with that. I'm not arguing that we have to deliberate on this. And Judge Wilkinson makes, I think, a very good point on this. The question, though, is the jury didn't have a lot of stuff that came up later, starting with the tips that came in right afterwards, and then the federal task force investigation, and then the witnesses who were interviewed pursuant to that investigation. I think the McCoy's whole argument here is the Schlupp actual innocence based on new evidence. I think is the argument. And our task is, when we look at new evidence, is assess it together with the old evidence. And so I'm not suggesting the old evidence wasn't adequately evaluated by the jury and could lead to a conviction. Just a question of the overall effect of the assessment we have to make.
Just a couple of points, Your Honor.
Yeah.
The point that I wanted to make is they credited his testimony in light of other evidence of alibi and another theory of a different shooter. They still credited Williams' version of events.
Yeah, that was a different guy named what? Forte, yes. Yeah, Forte. Yeah.
As for the Crime Stopper tips, Ballard was adamant that they have always been in the investigative files. He testified that he did follow up on those. He asked dispatch if there was any shots fired in Groveview Terrace that night. There was none. He said, with all the people that he talked to in his investigation, William Talley.
Were those tips made available to McCoy's lawyer?
That's, at this point, there's not been a finding whether they have or whether they weren't. It was an open file.
I mean, the
discovery.
allegation they make is they didn't get them until 2018.
That is the allegation. But even if they didn't get them at that time, they had a follow-up investigation on them. And it didn't turn up any exculpatory evidence. They found the one person who was named in the Crime Stopper tips as Little Irvin, and he said, "I never saw this shooting. I have no information to give you." There was 2 other people that they talked to, but again, they don't know the date of when this shooting occurred. They don't know who the specific shooter was, and the only thing that is right with all of this, the tally evidence, was the location of the car. That they could find that the location of the
was
car
there
the
evidence
same
that
place.
McCoy's the gun that McCoy generally carried was a .22?
That is what one of the co-defendants said, but Williams testified that he thought it could have been a .357 in the night when he saw the shooting occur.
Ms. Callahan, I want to ask you a question. has to do with confessions and corroboration. The law, as you obviously know, is that there is a requirement that a person cannot be convicted on a statement alone that's not corroborated. It must be some degree of corroboration to show the trustworthiness of the statement. Here's my question. Where a statement made by the defendant, which is alleged to be a confession, is vague or uncertain, as here, where the person says, I know it, I know it, I know it. It's not a direct admission to the commission of the crime. Does the uncertainty and the vagueness of the statement require a greater degree of corroboration than would normally be the case?
Well, the jury found that it was corroborated here. Your
Now, I'm
Honor.
asking you what the law is. What do you think the law is, and whether or not there's a greater degree of corroboration required when the alleged confession is vague or uncertain or not direct or specific?
Your Honor, I don't know of any case law that says that. I'm not certain on that.
Okay.
I mean, if a confession has to be corroborated, I would assume that any type of admission would also need to be corroborated, and it wasn't this case.
I couldn't hear, your voice dropped at the end. I couldn't hear what you said.
That his admissions, and I don't believe the state has ever referred to it as a confession, but as an admission, an incriminating remark. I believe it's the opposing counsel that wants to deem it as a confession.
Well, the charge to the jury was intended to be a confession.
Well, it tended to show that he admitted facts that he was involved in the crime.
Okay.
Yes, Your Honor.
Okay.
That's a confession.
Excuse me, I just thought that the interaction between Ballard and McCoy was not introduced as an uncorroborated, was not introduced as a confession, and we all know the basic rules that an uncorroborated confession is not enough to convict on. I just thought it was another piece of evidence. The nature of the interaction was another piece of evidence, which, when combined with Williams' testimony and the circumstantial evidence involved, was enough for the jury to weigh. It just has to be considered not in isolation, but in conjunction with everything else. It is very, very difficult for us to achieve the kind of understanding of a case that a jury has, or even that a later MAR court has, or a later federal evidentiary hearing has. And the Supreme Court, when it said that Schlupp was a very, very high bar as a gateway, took precisely that into account, that there would always going to be attempts to undermine the finality of state courts and the finality of a criminal trial. They knew that. They knew there were always going to be attempts to scour the woods after the trial. And that is why I think that they wrote Schlupp in a way that left very little room for evidentiary rehashes, such as we are undertaking.
Your Honor, I would agree with that. It's not an impossible standard, but it should be nearly impossible. And in light of this, he has not met the exacting standard of showing that in light of this alleged new evidence that no reasonable juror would have found him guilty in this case. So I would respectfully request that this court affirm the district court's order in this case.
Thank you. Counselor, Mr. Lau, you have some rebuttal time.
Yes, I'm hoping to make 4 points, but first to address what you just said. It is the rare case where a federal task force investigating a crime comes up with significant and strong, credible evidence that somebody else committed the crime. This is the rare circumstance. And I want to spend just a second talking about what that federal investigation did. Contrary to what counsel said, it was the person who testified, Ronald Perkins, told investigators it was common knowledge that an individual from Haymont Hill, McCoy, had been wrongly convicted for the crime that Haley committed. Bernard McIntyre gave an affidavit indicating he knew Haley from his interactions in the court and buying drugs, and it was Haley, and it was Haley's car down the embankment the next day. So there is significant evidence. But the task force investigator testified at the federal evidentiary hearing that they were careful. They didn't know anything about the Haley murder. They were debriefing these individuals as part of the federal indictments, and they were corroborating information that they were being given to ensure the veracity of the information they were receiving from these individuals. They were doing a careful investigation to ensure that they weren't being told falsehoods. And that's precisely what led them to the information regarding Cali killing Haley. And the state concealed, and now.
But the conclusions were somewhat inconclusive, weren't they not?
Well, those conclusions were inconclusive because of what the investigator testified to. They were not sure, didn't know the evidence that was presented against McCoy, but their conclusion was unambiguous that they believed those witnesses to be reliable and those statements to be credible. Additionally, I want to talk just briefly on the remarks that I carefully said were not a confession. There were remarks made during an interaction with Detective Ballard. The statement, the most direct contemporary.
The question I have is whether you're urging a standard of deference to an inconclusive federal investigative report as opposed to the deference where Congress placed it.
But Congress, and McQuiggan expressly says this, the totality of evidence has to be weighed with respect to Mr. McCoy and whether a reasonable juror would find him guilty. We don't have to prove Cali guilty. Additionally, McQuiggan expressly says that Congress endorsed the actual innocence gateway with regards to our burden is to show by a preponderance of evidence that no juror would find Mr. McCoy guilty beyond a reasonable doubt. And I submit that that's been exceeded here with regards to the information, new evidence not presented by a trial. On the remarks made to Ballard, the contemporaneous notes of Ballard in his felony investigative report is the best way to characterize it. McCoy was the only person, he says, on Joint Appendix 152 not to make incriminating statements. And as Judge Traxler pointed out, you have to corroborate a confession if it even could be determined that, but it wasn't determined that here by Ballard himself based on what he wrote himself.
Well, let me, Mr. Blau, I hate to interrupt you because you're on such a roll, but
Of course, Your Honor.
I do have a question about this confession that you're just talking about. The magistrate judge and the district judge put heavy reliance on the fact that the statements your client made could have been reasonably construed as a confession. My recollection of the testimony that Detective Ballard gave initially at trial was that to simply recite, here were the questions I asked, here are the responses I got. But later on in subsequent hearings following the conviction, he amplified that a little bit more and was asked and testified that he considered the statements an admission that this defendant had committed the crime. So now that confession evidence is even stronger, presuming we consider this later testimony, later evidence, whether it's admissible or not, that the evidence supporting the fact it was a confession is even stronger. So would you comment, am I right, am I wrong? Anything you'd like to say about that? Do you understand?
I do.
what I'm
And
saying?
29 years later, for the first time, Ballard amplified this to his opinion that it was a confession. But his opinion doesn't matter to this court's totality review with regards to how
But
reasonable.
it's still admissible, and isn't it still evidence we consider in applying SLUP standard?
I mean, I would say that the best indication of Ballard's belief with regards to the statement is what he wrote contemporaneously 29 years ago, or over 30 years ago now in his felony investigative report, that McCoy did not make incriminating statements in this case. That is the statement contemporaneous with the interaction. His self-serving testimony years later.
This is in the report.
It's in his felony investigative report, the joint appendix at 154. He says that McCoy did not make incriminating statements during the course of the Wynn interview. That was Ballard's characterization. Now, the state characterized that as a part of only discussing the formal interview once he was arrested in custody. But it strains credulity to believe that he would write that McCoy was the only person.
But the point Judge Traxler was making is that you're relying on after discovered evidence and whatever, and you're not relying on post-trial evidence. And in this one respect, Ballard's recollection is even more unfavorable to you than it was. In other words, you can look at it as a situation in which you say the state's case diminished over time, but at least in this one respect, you can indicate that the state's case actually increased over time. I mean, it doesn't go all in one direction.
I'm saying that the best way to put into perspective Ballard's view of what that interaction was he had with McCoy is what he wrote at the time, and what he wrote at the time is reflected in the felony investigative report. I see I'm out of time. If the court will entertain me to make one final point, I don't want to lose sight that there's a cloud over all of it. And that cloud being one of the two investigators, Robert Parker. Testimony in the federal evidentiary hearing made clear that he actively protected the very gang that was later said that Talley was the one responsible for this homicide. He tipped off Miss Howard when Fayetteville police investigators were going through that neighborhood to make drug raids. And that is something that should also be considered, and a jury would consider. That also clouds everything in this case. And with that, I respectfully submit to this court that no reasonable juror on the evidence before it could convict Mr. McCoy, and that the district court and magistrate should be reversed. Thank you.
We thank you. Appreciate your argument. Appreciate both of your arguments, and many thanks to our courtroom deputy for a fine job that she did. And we'll take a 5-minute recess, and then when the court is cleared, we'll come back for conference.
This honorable court stands adjourned, sine die. God save the United States and this honorable court.